Hello everyone, and welcome. Thank you for joining us for the first session in the 2022 Resource Sharing Conference virtual series on controlled digital lending for resource sharing, law and policy since 2018. My name is Travis Good. I'm the newly appointed Assistant Director of Public Services at the University of Texas at Dallas and a member of the RSC Planning Committee. I'm very excited to be here with you all today to help kick off the first session of the RSC 2022 as it brings us together, as it brings the resource sharing community together for an annual event and also encourages sharing and learning and gives us a new opportunity to connect with our colleagues around the world. Before we get started, please feel free to introduce yourself in chat and let us know where you're joining us from. I'm joining you from Dallas, Texas, and I already see a few people from Texas that have joined us. So please mention where you're joining us from. We will also take questions for today's presenters through chat as well. You can post your questions anytime, and there will be time for a Q&A following the presentation. We also hope that you will join us for an open discussion following the presentation today. The details for joining that meeting will be shared at the end of the session. As a reminder, this presentation is being recorded and a link to the recording and slides will be emailed to you when they are available. All right, now we'll be moving on and introducing today's speakers. We have Kyle K. Courtney, the copyright advisor at Harvard University, joining us, and also Dave Hansen, the associate university librarian for research, collections, and scholarly communications, and lead copyright and information policy officer at Duke University. And now I will hand it over to Dave and Kyle.
Thank you, and good morning, all. So I'm going to lead us off here with just some table setting. We're going to introduce the concept of just what is controlled digital lending at a basic level. And then the bulk of our discussion today is going to be about what has happened over the last 4 years, basically. Controlled digital lending has sort of caught fire in the last couple of years as the pandemic raged and people were looking for lots of different alternative access options as people are outside of access to libraries physically. But there's a much longer story that precedes this. So to start off, what is controlled digital lending? I have a very, oops, wrong way. Very basic definition for those of you who haven't encountered the concept before. Controlled digital lending is a system that enables a library to circulate a digitized title in place of a physical one in a controlled manner. So controlled digital lending is a term that was coined, I guess, a little more than 4 years ago, as Kyle and I worked with a much larger group of people to hash out what are acceptable and reasonable pathways forward for libraries to provide legal digital access to things within their collection. And as we all know, there's been lots of work on digitization and digital access for many years. I was just thinking, it was 2003 when go back to when Google started doing the Google Books digitization project. We're almost 20 years on from that, and through that digitization project and then some of the follow-on things that came from that, like HathiTrust, lots of organizations looking around and saying, how can we leverage these incredible opportunities that we have to provide more access to digital access to the materials in our collections? And of course, those two projects provided some access through public domain materials and other things where they were able to get permission. But on the whole, when you go to Google Books or HathiTrust, access to in-copyrighted materials is still very, very restricted. They were both involved in litigation that informed our approach to controlled digital lending, and that litigation dealt with much more conservative access basically for search functionality. And so, back around 2016, 2017, 2018, a group of interested librarians and lawyers got together and started talking about how can we help the community make some progress on providing access in ways that are reasonable and that fit within the law. That conversation started very much with a U.S. focus, and so I want to say just at the outset here, what Kyle and I are talking about is very much focused on U.S. law. That's not to say that controlled digital lending does not have application outside of the United States, but the legal framework is obviously very different when you're looking at other jurisdictions. There have been some great efforts. For example, there's a paper that recently came out in February focused on controlled digital lending of library books in Canada. And there are other similar efforts around the world to look at how the same framework could be applied under the law of different jurisdictions. So one of the results of those early conversations was a statement on controlled digital lending by libraries that describes CDL as an emerging method that allows libraries to loan print books to digital patrons in a lend-like print fashion. And as we worked through kind of the principles that underlie just libraries' ability legally to do the things that we have always done in lending physical books, we really focused in on what are those principles that make that economic system work, and how can we translate those into the digital world. And so if you go and look up controlleddigitallending.org, which Kyle has put into the chat, that includes a copy of the statement, which at a high level addresses basic principles for application of CDL. And on that website, you'll also find a link to a rather lengthy white paper that Kyle and I wrote outlining the legal arguments in favor of controlled digital lending and the characteristics and the limitations that libraries ought to think about applying to CDL to manage risk and to make sure that they're fitting within a kind of generally accepted framework of the law. So a lot of those conversations were happening around that time, but CDL actually has a much longer history. The basic framework, this idea of taking physical books, scanning a copy of them, and lending them out in a lend-like print fashion, meaning providing one-to-one access. You don't have multiple people accessing a copy at the same time. And where you're controlling access to the physical copy when the digital copy is checked out, so that you are maintaining what we refer to as the owned to loaned ratio, kind of maintaining that economically similar transaction. Well, Internet Archive had actually been doing that for quite a while. So this is an article from 2010, now 12 years ago, where the Wall Street Journal wrote up IA's approach to what later became known as controlled digital lending. So it has a rather long history, and led us into some additional pathways where we needed to define what libraries really do from a legal basis in a day-to-day transaction with physical materials, and let that kind of lead into what or how can we define a framework for legally lending in the digital context. And so this will sound a little basic, but is important to set the stage for how we get to the legal argument for CDL. So first, how do libraries legally do what we do? I'm not talking about digital lending. I'm just talking like basic, I have a book in my collection and I want to lend it out to users. And you might be thinking to yourself, why do we care about the law? There's no like legal implication there. But actually there is. There's a framework that we have to walk through to understand how libraries do that, and that helps inform how we get to a framework for CDL. So first, it's important to recognize there are these statutory exceptions in copyright. So copyright sets this basic set of rules. This is the outline, the table of contents of Chapter 1 of the Copyright Act. And copyright sets these basic set of rights that rights holders get. If you look here, these definition of rights at the beginning, what is covered by copyright, the subject matter, and then in particular, section 106, you'll see in very small font there, the exclusive rights of in copyrighted works. And So it defines these very specific rights that copyright holders get, but those are subject to lots of limitations. Sometimes we view these limitations as like special exceptions, but they're actually very much baked into the copyright economy. Without them, the whole thing would break apart. And how libraries lend books is actually a great example of that. So this is the text of Section 106, those exclusive rights that copyright holders get. It's important to recognize that sometimes we refer to this as like the bundle of sticks, the bundle of rights that rights holders get. It's not unlimited. They don't have unlimited, unfettered control over the copyrighted works that they create. There are some very specific rights, but they are broad. That includes the right to control reproduction. Sorry, there's my little bundle. That includes the right to control reproduction, basically copying, right? And that's a pretty broad and basic right. The other thing, if you look at number 3 on here, copyright holders get the right to control distribution of those works, in particular distribution to the public in all sorts of ways, by ownership, rental, lease, lending. And that's a very broad right if you sit down and think about that, right? I wrote something, I have rights in that, and I get to control how that copy gets distributed to anyone out into the future. Well, that sounds very, very extensive. Copyright holders also get other rights, for example, the right to prepare derivative works, um, and the right to control performance and to control display. I want to sort of cabin those for a moment. Those are important and may be important if we're talking about application of controlled digital lending to other media formats like film or video. But at the moment, what we're focused on is controlled digital lending of library books. And so from a textual perspective, really what we're focusing on is reproduction and this distribution right. And when we look at those two sticks in the bundle, they are very broad. And if we didn't have limitations on those, it would pose a real problem, right? For libraries to say, we bought a book in our collection and we want to lend that out to people. We need people to be able to use it. And we need something to accomplish that. And so we know kind of intuitively that that can't be the end of the story. There has to be more to allowing us to make use of these works. And it's true, actually. It's been the case for well over 100 years that the courts have recognized that that right to control public distribution, or in the past it was referred to as the right to control, to vend, is limited. And there's still some confusion. I thought this was entertaining. This was just a couple days ago, showed up on Twitter, someone showing a statement that was posted in the front of a book, basically saying that you can't do anything with that book once you have it. It's for your personal enjoyment only, and that the book cannot be resold or given to other people. And that's an interesting attempt to control downstream distribution of that book or that copy of the book. But it's ineffective. The courts have said for a very long time that you basically can't do that. The Copyright Act sets up this balance of rights as between rights holders and users. And one of the things that users get is the ability to control use of particular copies that they buy. So this is where the doctrine of first sale comes in. First sale basically says that notwithstanding Section 106.3, that's the public distribution right, says the owner of a particular copy lawfully made under this title is entitled to sell or otherwise dispose of the possession of that copy. So that basically says the rights holder gets to control the very first transaction that happens with a particular copy. But after that, those rights are exhausted. In other parts of the world, this doctrine is often referred to as the exhaustion doctrine. So that's the basic, like how we lend physical books. You have to jump through these hoops, and every time a book gets checked out from your library, all of this legal process and all of this legal framework is happening behind the scenes to make that happen. So one of the challenges that we face when we're talking about digital lending is that there's an additional right implicated, right? So it's not just that we're distributing the file. In order to effectuate controlled digital lending, we have to have an intermediate reproduction made, right? Just that's the way computers work. When a file is moved to a computer, that file is reproduced. And so we have to think about not just the distribution right, but the reproduction right as well. And luckily, the Copyright Act includes mechanisms to deal with situations where you have multiple rights being exercised at the same time, and where technology has sort of changed the situation from how the Copyright Act has initially defined the framework for analyzing the situation. And the main tool that we have to deal with that is fair use. And so fair use applies very broadly. It takes a kind of principle-based approach and says, notwithstanding Section 106, that group of rights that copyright holders get, the fair use of a copyrighted work for all of these different types of purposes, these are all listed as kind of examples, is not an infringement of copyright. So fair use is a little more nuanced than just looking at those examples. What the courts and what Congress gave us are a list of factors that we're supposed to consider and think through when trying to apply this doctrine to any particular type of use. It's very fact intensive. It is very much dependent on the particular circumstances that you're applying it in. But as we run through these, the basic argument for CDL looks pretty good. So first, we look at like the purpose and character of the use. Well, in the nonprofit library setting, where we're mostly lending materials for the purpose of enabling learning, research, those sorts of things, that actually ranks very highly for fair use purposes. Those are very similar to the examples that were given in that preamble section that I just showed you. So that's pretty important. One of the other things that shows up in some fair use cases is also a recognition that fair use ought to facilitate other congressional statutory objectives. So for example, the Americans with Disabilities Act talks a lot about providing access broadly to people who have a variety of disabilities. And so the courts have looked at things like fair use and said, well, we can use fair use to help accomplish those objectives. And we've seen that in some other cases too. And so one of the very strong parts of the fair use argument for CDL is that fair use is being used to accomplish those same sort of economic objectives that are baked into the first sale doctrine. Some of the other factors, the nature of the work and the amount and substantiality used, don't always come into play quite as significantly in all fair use cases. And we believe in this situation, they may not carry the day. You know, nature of the work looks at things like, was the work published or unpublished, with published works tending to get treated more favorably in the fair use analysis, which for books would carry here. But also those two are very much dependent on the strength of the first factor and the very last factor. Which brings us to then the last issue here, the last factor, which is what is the effect of this use on the market for the work? And I could spend a lot of time talking about the different market characteristics of different print books, and I know that lots of people on this call know an incredible amount of what that market looks like. The basics of the fair use argument here is that what we're trying to do is maintain economic parity with the initial print transaction, right? So the library has paid for that book or otherwise legally acquired it. So there was a market transaction that happened, and we're not trying to really get more than what we paid for here. We're just trying to shift it into a format that's more meaningful and useful for users in 2022. And so you could argue that there is a market effect there, right? We're lending out a book, and that could represent, you know, a lost sale. Maybe there was an ebook that could have been bought, or even a print book. And that's not really the market that fair use is concerned with. That's part of the market balance that Congress has already set up. I mean, just the fact that libraries exist is a potential market harm to rights holders, in that we buy one book and then lend it out to many people. And theoretically, each one of those lends could represent a lost sale or some risk of a lost sale. But that's okay. That's baked into the market. And so what we're trying to do here is mimic that kind of market effect, not totally eliminate it, but maintain the status quo. So at its core, CDL is about replicating that with digital lending, that legal and economically significant aspects of the physical lending. And so in this statement that we helped draft, and in our white paper, we identify a few characteristics that are really important to keep in mind, and just list them here. You can go back, and this is a lot of text, so I won't read this off to you, but some characteristics of how to make CDL as close to that physical, legal and economic situation as possible. The key things here are, limiting the total number of copies in any format in circulation at any time. So I saw, I'm not paying super close attention to the chat while I'm talking, but maintaining that if we have a physical copy, we're not lending that out at the same time as lending out the digital surrogate of it. And then placing controls on that digital copy to make sure that copies don't proliferate. And so with that, I'm going to hand it over to Kyle, and he's going to take us into the current situation of just what's happened with CDL over the last several years.
All right. Hi, I just wanted to turn on my camera and say hello to everyone, but I'm going to turn it off for for purposes of saving a little bit of bandwidth. But thanks, Dave, for doing that. We keep talking about the white paper, so I thought I'd just throw a link in the chat. If you like a nicely clean version that's not HTML, we host one online, so you can have a look at it there. As Dave said, though, those were the foundational basics that we wrote back in 2018. But of course, just for the record, people were interested in it, but not nearly as much as when we had the unfortunate occurrence of the pandemic, closing most of our libraries as well. So the explosion interest has been fascinating and rewarding. And just as of now, over 100 US and Canadian libraries, and with one other country coming on board soon, actually, and publishers have harnessed the CDL system to loan digital copies. And I'll note that it's sometimes specific collections like the Allen County Public Library's genealogical collection. Sometimes it's back catalogs of particular publishers, Houghton Mifflin Harcourt, for example. The Brickhouse Cooperative, which is a bunch of journalists that get together, decided to sell digital copies to be CDL loaned, but also some major library systems, both law library, university library systems, are using some version of CDL. So that is a rapid and fast explosion. And again, as I was indicating earlier, it's due to the fact that we had these COVID closures, right? The COVID closures did something interesting. It had us look inward at the collections that we had that were on our shelves that were technically unavailable to our community because of public health closures. And so, as we know, certainly control is one aspect of controlled digital lending. So a lot of people asked if these closures afforded an opportunity for the libraries to start using controlled digital lending as a method of loaning that which they could not access physically. And overall, it came out to be that CDL illustrated some of the limitations that we have on our physical collections that we potentially could take advantage of during this a terrible time for the world. So at the height of the closures, over 625 million books, it was estimated, were trapped in libraries. And these are things that are already on our shelves, which we have purchased, which we have rights over, right? Significant legal and economic rights. So this problem with the closures illustrated that we need to expand digital access, right? With the shutdown of these collections, we had to do something. And a lot of places were like, we need to do something, either temporary or permanent, but we need to do something. And that physical access, even limited physical access or picking up works. I know a lot of public libraries had like drive up library and stuff, but the context here is it wasn't enough for lots of vulnerable populations that we currently serve, and not just through the pandemic either. I worked with a lot of public libraries that had seniors that could not come in, or people that were disabled for accessibility reasons, that were deployed overseas. We had a lot of reasons why physical access wasn't enough. So we needed to develop some either backup options or explore permanent options. And this was across, which is great, all of our communities, whether public, private, university, historical societies, everyone was considering this. So it illustrated this. Now, here's something that's really interesting. We're already in this space, right? It's not like libraries haven't entered the world into digital. We've been doing electronic document delivery, digital interlibrary loan, some places doing virtual reading room for years, right? The old concept of resource sharing is a natural outgrowth of our mission. And so this is just another step. You know, Dave and I view this as a reasonable step, just being heightened by the pandemic's curbing of our mission, but it doesn't have to. And our users are already in the digital space. This is one of the things that I will trumpet on high. Some of my students that I work with basically have told me nothing exists to them unless it's digital in some way. So why would we be restricted from this digital space where we have already been operating for decades, where we've already been doing resource sharing, but CDL is somehow one step too far. And so that's where we started in moving the white paper from just a paper to actual practice. And this increased the ability for us to explore different options. We basically said, read and use the white paper, please, right? We made that available. Now, we saw this reflected in various efforts. HathiTrust's ETAS, which I'll talk about in a moment, the formation of the Controlled Digital Lending Implementers Group, which basically has monthly meetings since 2020 of people exploring or using and implementing CDL across the United States and Canada. We also saw a lot of CDL for reserves, one of those temporary limited methodologies, but one in which we had already been doing reserves work for a year, and a variety of other local implementations that also serve distinct communities. And I think that's kind of some of the most exciting part is this experimentation that we have seen that is built off this paper. I'm calling out HathiTrust here specifically because theirs was called the Emergency Temporary Access Service, or ETAS. Now, they did not define this as controlled digital lending. They defined it as well within the rights that they had in the creation of the HathiTrust corpus. Now, mind you, a little background. HathiTrust formed up as a result of universities working with Google Books. Google Books came in and scanned the entire corpus. They got to go off and form Google Books. As part of the deal, they donated all the scans back to the university libraries, which then formed HathiTrust's corpus. Basically, HathiTrust is the living embodiment of that own-to-loan and friction elimination that Dave was mentioning before. Own-to-loan meaning as many books as you have in your collections, we can check out, right? So if 10 universities have one copy of that book, that's 10 potential users that could check out that book that are Hathi member libraries. And friction elimination is we don't have to wait for the van or the bus or the interlibrary loan unit to cart those books around, to ship them, right? As soon as someone's done, it goes to the next person. So Hathi member libraries and their patrons could check out a book digitally for 1 hour. I'm sure many of you maybe even saw this. Access would renew automatically. And then unless another user requested the book, and then it would go to them instead. And my favorite part, they had a return early button, which is amazing, right? No waiting for shipping, no concern about the book being late. You can return it early and the next user would have it. And again, because it eliminates that friction that happens at the CERC desk, that friction that happens in the Interlibrary Loan Department. This is just one example of an interesting method. Now, this is very much built off something that we should be very familiar with. Dave outlined this in the first sales scenario, but we acquire a copy as a library. We check it out to one person at a time for a limited time period. We then return it to that library, right? The concept of returnables, and it's made available to the next person. And we repeat that process. And again, because of the exceptions that Dave outlined, without permission from or more fees paid to the copyright holder. This should be familiar. By the way, this is a digital loaning system. It's also a physical loaning system. It's also the reserve system. It's also the interlibrary loan system. Everything is based off of this particular system. So one of the more interesting ones that developed at the time and really grew during the pandemic existed long before that was the Open Library system. Open Library is Internet Archive's version of controlled digital lending, right? And it was launched in 2007, actually, with the goal to make all the published works of humankind available to everyone in the world. which is an amazing, amazing mission statement. Now, Open Library had more than 1 million public domain items that it had scanned in initially. But then they moved into the physical realm where they were scanning collections of partners for library digitization, and expanded by the fair use analysis. This method was then renamed after those series of meetings as controlled digital lending. So by 2017, 500,000 books were available to borrow under CDL, and IA eventually formed the consortium called Open Libraries, which relied on the physical holdings of the partner libraries to expand access. And this way, using something called the statistical method, in which they count up the number of books that are available and in the systems, the Open Library could lend a particular work to more users simultaneously, but still maintain that own-to-loan ratio, right? They can't lend more than their partner libraries have. So again, currently it's up to 1.4 million books available for borrowing. Now, this wouldn't be a good segue if we didn't at least mention the National Emergency Library. The National Emergency Library launched in the same way in response to a COVID-19 pandemic closures. And they cited, when they launched this, an unprecedented global and immediate need for access to reading and research materials. Right, so IA did something interesting here. They suspended their lending limits so that all materials were immediately accessible to borrow, even if used by another borrower. And in that way, it altered one of the primary controls of the CDL system. National Emergency Library did not restrict loans to one user at a time per copy. Legally speaking, according to Dave and I, NEL is not CDL, right? However, NEL did use the same CDL technology that runs the Open Library program, and other practices remained, such as access ceased after a 2-week loan, and the work was restricted to prevent any copying or redistribution. So the NEL program added a simple opt-out process too for authors who did not want their works available in this manner. If you didn't want your book in the NEL, you could write them and they would take it out. And by the way, they didn't allow any works that were published within the last 5 years to include in the NEL. So that was some of the difference between that system, but I just want to point that out. However, both systems, CDL and NEL, were mentioned in the lawsuit. And of course, we have to talk about this because they cite into the white paper. In this, the publishers filed a complaint in the United States District Court for the Southern District of New York in 2020 that targeted the National Emergency Library and the legality of controlled digital lending. Now, the outcome of this case will largely hinge on whether CDL or the NEL fall within fair use doctrine of copyright law. And I'd just like to just quote a couple things from the publishers. Though they filed a complaint, and in the complaint, they do profess their love of libraries, both Hachette, Penguin House, HarperCollins, Wiley. We love public libraries and long supported public libraries. However, they also inexplicably claim that their mission is not one of for-profit or generating revenue for the shareholders and investors, but one of education. And they said something here that's really interesting. It says, Internet Archive merely exploits the investments that publishers have made in their books and does so through a business model that is designed to free ride on the work of others. And for a moment, and someone did this in an article I just read recently, they took out the word Internet Archive and they replaced it with libraries, right? That idea in this complaint seems to be a veiled attack on libraries. And so just for the moment, play along with me. It is authors and publishers who create the books of scholarship and literature for educators, students, and other readers. Libraries create nothing. Libraries play no role in the hard work of researching, writing, or publishing the works for that ecosystem. I'm skipping a little. Moreover, libraries' massive lending business has no new purpose that is fundamentally different than that of publishers. Both distribute entire books for reading. And then they close with that sentence that, got my attention. In short, libraries merely exploit the investments that publishers made in their books and do so through a business model that is designed for a free ride. Libraries undermine the balance and promise of copyright law by usurping the publisher's ability to license and sell the books that they have lawfully produced on behalf of others and for the benefit of readers. a lot of people that looked at this, and you could put in interlibrary loan, e-reserves, the word libraries. This is not just a general attack on Internet Archive and the process of controlled digital lending. This is an attack on loans in general. And I think this is why I was very excited to talk with this community, because this is a veiled threat that the publishers will be able to license and sell, and the libraries are taking a free ride. And it gets back to something that Dave mentioned earlier that I wanted to enhance. Every loan of a book is not a lost sale. It seems to be that they think it is. And as many of us recall, in 2018, when Macmillan said that library loans were cannibalizing their sales, and they used that word, cannibalizing, we saw the height of the struggle. And a few people had mentioned that they're finally saying the quiet part out loud. And so CDL just represented a front for these publishers that was too much. Now, I obviously disagree with most of that. I think Dave reviewed those exceptions for you. We don't undermine the balance and promise of copyright. In fact, if anything, libraries care very much about the balance of copyright. However, we do not license and sell every book, right? We open the access and make it available to everyone. And Congress, in their wisdom, has enhanced the vital service that we give to society through reserves and interlibrary loan and other elements of resource sharing. So we're hanging on hat on every loan of a book is not a lost sale. This is a hard thing to overcome. But I just wanted to mention, just for the moment, that the lawsuit process does not mean anything has been decided. Everything that Dave and I have talked about today, over 100 libraries in the US or Canada are doing this, are certainly watching this. But this is a long legal process. I'd just like to review that basically. I just went over the complaint. The complaint was filed in 2020, which is the first step in a lawsuit where the plaintiff lays out their version of the events and describes how the defendant's actions harm them, right? And usually they ask for monetary compensation or injunction or something. We have had that complaint. We saw that. Also, Internet Archive has answered that complaint, and that was their opportunity to respond to the complaint. Now, no legal arguments have been made here in the answer. The answer provides the defendant's versions of events and either admits any statements in the complaint are either true or denies that they are true. That's about all that happens in the answer. Then you move into that next phase, discovery. And this is the process where everyone gathers evidence, right? It allows each side to get documentation, to get a better understanding of their legal position, and to develop strategies for the arguments that are to come when they actually go to trial. Now, this involves depositions, or basically interviews with interested parties, interrogatories where you answer questions via email. It also is a lot of document production, right? A lot of documents are shared. And that has also happened in this case. What hasn't happened yet is motions, trial, or appeals, and that's coming soon. Motions is probably the most interesting part in the beginning cycle prior to trial, and this is where either party can try to end the case by filing a special motion with the court that says, hey, we don't even need to have a trial, right? It's called summary judgment. We don't need to have a trial. This is clearly in our favor. Or the other side files a motion to dismiss and says, you know, there's no reasonable reason that we should have a trial here. We should dismiss this for the following reasons. Motions are happening now. That's going to be happening late spring or early summer. And that can take a very interesting path, because you can actually have appeals process over motions to dismiss or summary judgment motions, meaning higher courts can hear it and they can appeal it, and then it comes all the way back down. Eventually, when the motions are over with and any appeals underlying motions, then you actually have trial. When trial would come on this case is probably earliest of November of 2022, maybe later, depending on how everything goes. And then a decision a year from maybe even now or further out. And then there's the appeal. So this is a long way to go. And I would like to remind everyone, nothing has been decided about controlled digital lending yet, right? It's being used currently. And I would remind everyone on this call, if they want to think back to the e-reserves case that occurred many moons ago, that took 12 years to decide if one chapter or two chapters on an LMS or Blackboard or Canvas was either fair use or not. 12 years to make that determination. Did we stop using e-reserves in those 12 years? Absolutely not. We did not. So just note, it's a while before we decide. So is there support going on now? This is kind of interesting. Yes, there's massive amounts of support. These major organizations all signed on the initial statement. Many, many more that I can't include their logos on the screen have supported it. Further, we have seen vendors step into the CDL space and either allow their software or platforms to be used for CDL, or specifically developing CDL interested software expansions of their software, which is very exciting in many ways. So we've seen libraries do it, we've seen publishers do it, and now NISO has entered the fray. This is a technological project to develop a consensus framework in support of CDL to be published as a NISO recommended practice. And this framework will describe the existing practice and decide best practices, including for circulation, for interlibrary loan, and other aspects of CDL. So this is very important for this, because NISO interoperable technical standards are very important to our communities in general. So overall, I hope at least Dave and I have discovered that because this is being used by so many people and its methodology is interesting and being developed, and we've allowed the last 2 years of experimentation, this seems to be a low-risk, reasonable solution that preserves the legal and fiscal value in the library collections that we have built, which is amazing. So I'm going to kick us off with just a couple words about CDL for resource sharing, and then Dave's going to take us home here. Just real fast, obviously, if you believe in CDL, then you should believe in CDL resource sharing, right? Interlibrary Loan has been around for a while, and that concept that it adds certain historical prestige to trace its development to trafficking in clay tablets, which I read about years ago, and to indicate variations on the purposes and techniques since the ILL code was written down in 1917, the principle is the same as it is today: to aid research calculated to advance the boundaries of knowledge by the loan of unusual books not readily accessible, and to augment the supply of books for the average reader, including the average book. And this is where we get a little bit of a difference here. Section 108 is the engine behind most resource sharing activity, including document delivery, preservation, and interlibrary loan. So I believe Dave's going to come in here and talk a little bit about the dream of shared access as we close out the session here.
Thanks, Kyle. Yeah, I'll jump in here on this. I did want to mention too, on that slide, Kyle had a bunch of the different organizations that have supported CDL and the different vendors who have gotten involved. I think it's also important to recognize that there is not like universal publisher or author opposition to this. In fact, even to the National Emergency Library, in the midst of that, there was this really nice press release put out by the University of North Carolina Press and Duke University Press. And so even at that kind of political level, there's a good deal of agreement, especially among mission-driven authors and publishers, that this is the right thing to do. We ought to be leveraging these collections for broader access. And I think that fits really nicely in with the consortial, or the resource sharing part of or application of CDL. So there has been for a long time this dream that, if we're able to do digital lending with our users, how much better can we be as a community of libraries if we can leverage that for all of our users, pulling them together? So Michelle Wu, who's the former director of the law library at Georgetown and a lawyer, wrote a really compelling argument in a paper in 2011 titled "Building a Collaborative Digital Collection" that essentially outlines the case for using controlled digital lending to lend materials amongst institutions, amongst libraries, for the benefit of our users. It just makes so much sense from an efficiency standpoint. We're talking about using a common set of digitized material, similar to how HathiTrust operated with its emergency temporary access, right? They were the centralized repository of these digital texts, and we're relying on institutions that had their own physical holdings to lend those things out. So just from an efficiency standpoint, you gain a lot. But of course, there's more than that. The real ideal with shared access is that we're able to take collections that are far-flung, that are really special, even unique, and open those up so that users across a much broader spectrum of libraries are able to use those. So there's been some efforts really trying to hammer out what this looks like to use CDL as a mechanism for resource sharing. One of the groups that has formed around this to help move this forward is something called the CDL Co-op, which is, I'm going to skip ahead a little bit, which is listed here. This group of individuals who are all associated with libraries and have some legal expertise. And we've been working together over the last, I guess it's a year, working on how to help other libraries understand how CDL fits in with this picture and how to navigate some of the legal issues with using CDL in this broader way. So some of those issues, Kyle and I are currently working on a second white paper working through CDL for interlibrary loan, and part of this is just clarifying how CDL is different from some of the other types of like document delivery type uses that we make under Section 108. So Section 108 is focused in, particularly Section 108D and E, talk about making copies for users, either of small portions of materials or even whole books. But it's a very different framework. And in a way, Section 108 is actually broader and more permissive than what we are proposing with an application of CDL. Section 108, for example, requires no limitation on the number of people who can be looking at those reproduced copies in relation to the original physical. You could have a physical book in your collection and copy a chapter or even the whole thing multiple times and have those out to different users. So in a way, it's actually broader. And what CDL is focused on is actually creating a system that's roughly equivalent to what we use with returnables, right? Physical book gets lent out to another library, a user uses it, only one person's looking at it at a time, it's just in a distant location, and that's essentially the same idea for using CDL. The other place that we feel needs some clarity is about application of CDL to ebooks. And in general, the principles of controlled digital lending don't come into play there. And that's primarily because there are licenses and contracts that govern how libraries relate to the rights holders for ebooks. And so CDL is sort of dealing with the default copyright system, the default set of rights that we get under the Copyright Act to lend materials and exercise our fair use rights. But when you throw in a license or a contract, it changes that whole dynamic. And that's a whole separate issue. That's another major problem, as I think many on this call know, of what those contracts look like and what they allow us to do or not do. But that's not the issue that we're trying to address here. So those are separate. And then a third big issue that we're going to try to address here is what are the risks associated with lending beyond a library's main user group? So for example, let's say my library has a pretty risk-averse approach to controlled digital lending. Like we want to do this, we want to allow people to get access to our collections more broadly. But we don't want to digitize super modern materials. Like we think that maybe those are higher risk, maybe they'll cause more lawsuits or something. And so we say, well, we're not going to lend things that were published after, say, 1989. Well, what if one of my users borrows, requests, and we facilitate a borrow from another institution that's much more aggressive, and they scan a book that was published last year, and it comes in, and then turns out like there's a lawsuit around that. Well, I think the principles of CDL still hold up, and there's a good legal argument for defending that, but it certainly raises the risk. And so how do we share risk and manage that risk amongst institutions is a really important question when we may have different models mixed together. The primary underlying thing, though, that we need to keep emphasizing is that digital access and loans do not negatively affect the market any differently than the legal uses already permitted by libraries. And in the interlibrary loan context, that's no different than the direct loan to our users. Some of the objections, some of the issues that come up here are the same. You know, one of the arguments that we hear is, oh, well, physical books wear out. And so that's really a different situation than digital books or scans. And I find that pretty laughable when you look at the costs involved with maintaining digital files. In fact, they're extremely expensive and extremely complicated to maintain the integrity of those files. They absolutely wear out. They wear out in different ways, but it's a major issue. Another issue that is often raised, one of those friction issues, is that, well, physical materials are very difficult to ship and move, and that friction is part of the market that's built in for the print market. And again, that's one that we can look at, and you pull that apart and you say, well, yeah, that is part of the physical situation that we have when we're talking about returnables and sending materials between institutions. But that's not a market that the copyright holder gets to exploit. That is, you know, maybe we're harming FedEx, maybe we're harming UPS, but they don't have a right to that market. And so that's not really relevant from the copyright standpoint. And all of those same things are true for this as well. So I don't want to spend a ton of time going through this statement on controlled digital lending as a mechanism for ILL. It has a lot of detail. I did want to highlight a few of the different pieces of it and give you a sense of what we're trying to accomplish. So what we're aiming to do there is a few things. One is just increase awareness about CDL in that context and affirm libraries' rights to use CDL as a way to accomplish interlibrary lending. And then lastly, just to improve the service provided by the resource sharing community with these, so that we're all kind of on the same page about what is going on here. And so when we developed this statement, there was this group that was listed on the previous page that did this, but we actually involved and solicited a lot of good comments and feedback from a broad segment of the community that has helped inform what this statement looks like. So just to give you a flavor, you know, we talk about how interlibrary loan is just foundational, a congressionally protected practice, long empowered by copyright law. And, you know, going back to what Kyle was talking about with the Internet Archive suit and this real attack on the kind of fundamentals of how libraries do our work, it's important to say this, that interlibrary loan is an intrinsic part of the system. And that just because we're using different technology to accomplish it doesn't make it any less part of the system and any less part of the existing market balance. And that's a really critical thing for us to recognize and keep beating the drum on, because I think it's easy in the publishing in the licensing market that we have to have that reality squeezed out. There's a lot of talk about balance and balance in favor of authors, and you know, really, libraries are the balance that we are part of this system to enable users who, you know, otherwise can't afford to get materials to have some, probably not equal, but at least you know, some semblance of access and some ability to engage and learn at the same level as everyone.
Dave, I'm gonna pick my favorite one.
Yes, go ahead.
You know, there's a lot of them here that are good, and I put the statement in the thing. But if we could just go to number 7, number 8. Interlibrary lending, physically or digitally, is a legally protected activity within the marketplace. This is exactly what you were just saying, right? Here's the market that we have and employ. And so using controlled digital lending as a mechanism for ILL has the same effect on the market as other methods. I like putting it as a non-threatening thing. Like, this is, if you believe in CDL, then you have to, because of the returnable nature of it, believe in CDL for ILL. And I think that's a critically important part of this. Some of these statements are obviously, you know, important for our community to know, but for outside the community as well, Dave. right? That idea that we're telling them interlibrary loan is a thing, it exists. And that's why Statement 9 got the most thumbs up when we went to our peers and said, we know this best. Everyone on this call is well versed in digitization, access concerns, technology, resource sharing platforms. And so I think we're describing what we do on a daily basis here in a statement that just says these are all linked together. And when we were drafting this, one of the exciting parts was we noted that the tenets of interlibrary loan resource sharing and the tenets of controlled digital lending are the tenets and mission of libraries, right? We were just basically repeating in the same way what we are meant to do, which is to continue to provide open, non-discriminatory access to books for our patrons. And I know that there's a lot more of these, and I think we're running short on time. So I didn't know if
I think we're right at the end here.
Oh, good.
We've got a couple more slides, and actually the very last one I was hoping you would take here about legislative and policy efforts. We
Yes,
talked about
of
the
course.
lawsuit and all of that. There are other ways to deal with and address how to make the law fit with what is really necessary for libraries.
Absolutely. So the dream of controlled digital lending being just another tool, another arrow in the quiver of tools that we have as a library, can be done through legislation. As you noted, Dave and I have reviewed lots of kinds of legislation today, right? Section 108, Section 107, Section 109. But there's always that idea that, is there a concern in letting the courts decide? Because again, it took 12 years for e-reserves. Do we have to wait for 12 years? Well, no. Dave and I both work with an organization called Library Futures. I co-founded it, so I'm a little more involved. And Library Futures is a nonprofit group that's designed to fight for the right of libraries in the 21st century, and especially, obviously, focused like a laser beam on digital rights. So we did some hill walks, both physically and virtually in 2019, 2020, and 2021, talking with members of Congress about controlled digital lending. And I floated this idea. This is not a real idea. I call it CDL the bill. But that idea, like, would we have to do something legislatively? Would we have to amend the Copyright Act? There's a lot of discussion. Could we amend Section 108, which drives resource sharing, to be reflective of something basic that would reflect the fact that CDL is just another tool, just like interlibrary loan, document delivery, and preservation are in 108. It would have to be a particularly narrow focus, but there's a lot of concern about careful legislative process for this, right? When you open up something, introduce amendments, right? Often libraries aren't the power brokers in the room with regards to legislation and policy. We have important things to do, but that concept that CDL could be there is kind of interesting. So certainly these discussions are happening, but nothing is definitive. And so that is the last slide.
So we have a few questions, and we wanted to get to some of these before jumping into the discussion portion. Kyle, I think you can see them on the other screen.
Yeah.
But I'll just try to address a few of these, which I think are pretty easy to get through. The first is about international lending, people having users in other countries and how CDL might apply to that. So the framework that we just talked through is entirely based on US law. There are other good analogs in other jurisdictions. This is just general advice for anybody thinking about a CDL system. That's you want to talk with your lawyers, whether you have general counsel or if you're a public library, if you want to talk with your county or city attorney, but especially if you're thinking about international application. And really, when you start looking internationally, it becomes more of a risk balancing exercise than precise examination of legal systems all over the world, just because it becomes kind of impossible to do that for 180 different jurisdictions. But I do know of some libraries that are doing it currently.
Yeah, I'd just like to say, like, I worked in interlibrary loan and resource sharing. That's how I came up. I interned in that department. We used to ship books all overseas all the time. right? And I used to pay in IFLA dollars. So I'm very appreciative of that question that, we used to pay our IFM fees for loaning a book. IFLA, and I put it in the chat just now, released a statement on international CDL, basically endorsing that method and saying we should probably do this for all libraries. Now, that's a great statement, but it made me think about, I don't feel particularly limited with regards to interlibrary loan for physical books, except for the shipping time. Wouldn't it be amazing to decrease all that shipping time and all that friction by harnessing CDL in that way? Great question.
So another question that came in was about what platforms are libraries using to lend digital copies of books. And I think a really great place to look for that, CDL implementers included a
Yes.
link earlier, and there's some really great resources to look through there that identify the wide variety of different ways that people have implemented this on
Yeah.
the platform.
And they do monthly meetings. Like, it is not like this community has slowed down. I'll put that link in there again. We have an open Google chat listserv. If you want on the ground detailed review of these implementations, we have someone basically come in monthly and talk about it from all kinds of libraries and from all over the world, actually, which is really interesting.
So one other in here is about the National Emergency Library. Why did it close down so quickly? And that was actually by design. Internet Archive set that up as a very much a stopgap. Think back to the beginning of the pandemic. Everything stopped. I know at Duke, we had students couldn't get back to the country. They couldn't get their books on time. All sorts of international transactions, particularly physical ones, just came to a grinding halt. And so they said, as a stopgap, we're going to set this thing up so people can get additional access when they need it, but we're not going to run this forever. And that's what they did. They followed through and they shut it down within a matter of months as the global supply chain basically restarted at that point.
Absolutely.
I'm looking through the others here. There is a good question. This comes up often. Is it possible to use CDL for visual works akin to literary works? I often get asked questions about how we could use CDL for other types of formats. The white paper that we wrote is very much focused on the marketplace for books. The same basic fair use arguments, I think, hold true for other types of materials, but the market is very different. And so that part of the analysis, I think, would change. The other thing is when you're talking about visual materials or certainly moving image, you start to get into some of those other rights like public performance or public display. And so the analysis is a little more complicated. And the other thing is the risk in some of those fields is much more significant just because of the aggressiveness of rights holders. But the same basics would apply. That's one where certainly if you want to do that, it's really important to work through what the legal rationale and the kind of risk factors are for your institution.
And I think that question gets to what was alluded to earlier with what about ebooks, right? What about visual? And certainly music and film and visual audio are more likely to be licensed than the materials that are on our shelves. Remember, if you put a line down the middle, CDLs for everything we already have on our shelves and own in some capacity that we can utilize a first sale fair use analysis for it. Our future collections, right, have the problem of the licensing of the ebook problems. But Dave, I mean, you and I have been doing this a while. That's probably the number one question we get. Can I CDL this movie?
Yeah.
That's, and I just like to remind everyone, CDL is but one tool in the arsenal in which you can do this. Fair use alone can get people a long way here. But this is a specified purpose. CDL is for the things that we have already legally acquired and have access to because as a result of being part of our collections.
Yeah, I think a really good example of that is I had a conversation with folks recently about VHS and how to digitize VHS and make that available to users. And CDL, in my opinion, isn't the greatest option for that because we have other tools that can allow us to have broader access. And so there's a great project that Kyle and I are both part of that is working on basically investigating the rights situation behind VHS and when those can be made available. There's a great report out of NYU called Video at Risk. So for that kind of thing, it's often worth looking a little more broadly.
But it naturally gets people to talk about these things. That's what I like about it. CDL fosters conversations about access that we may not have had before about our collections, and this is why I think resource sharing might have the most promise in that.
So one last one I'll address, and then we can go off to discussion, is about security procedures. Like, how do you make the digital copy that you're creating? How do you make sure that patrons can't, redistribute and control that? And there are a variety of ways to do that. In the paper and in the statement, we talk about using DRM to control that, which sounds like antithetical to everything I otherwise tell people, but does provide effective control. And one of the things that I think is it makes for a very good argument here is that several libraries that have done this have said, we're going to use the same security features that publishers use to control access to their own ebooks. So they're using Adobe DRM, we're going to use that too. And I think that's a really powerful argument and counterpoint to this idea that libraries are just making copies that are going to get distributed everywhere out into the world, and it'll destroy the market. Because if publishers are confident enough in that technology to prevent that from happening with their own licensed ebooks, I think that makes for, we should have the same confidence that we can use those same systems for our digitized copies. All right. So I think we are good for Q&A. And I'm just looking over here in the chat for any discussion, direction around discussion.
Yes, Dave. So I would like to thank everybody for joining us today. And we will have the presentation recording and slides available within the next week. And if you'd like to continue the conversation with today's presenters in our discussion session, please join us at the link posted in chat.